If you own a home in Iowa and somebody called you out of the blue with a cash offer that sounded too good to walk away from, pause. Iowa changed the rules on what those buyers have to tell you before you sign. If you don't know what to look for, you can end up locking up your house for weeks with a middleman who never planned to buy it, only to flip your contract to someone else. In the next 10 minutes, I'll walk you through what changed, how to spot a deal that puts you at risk, and what your 2 minutes of due diligence look like before you put a pen to anything. I'm Jeremy Danilson. I'm a real estate attorney in Iowa, and my firm helps sellers, buyers, lenders, and realtors close property deals all over this state. Before we go any further, let me say this. A cash offer on your house isn't automatically a bad thing. A lot of legitimate buyers and investors use cash. They close fast, and they make life easier for sellers who need to move quickly. This video isn't here to scare you out of that, but Iowa now treats one specific type of cash buyer as a regulated category. That type is called a wholesaler. And if the person who called you is one, the state says you deserve to know that before you sign. So let's start with the change itself, in plain English. No statute numbers, no legalese. For years, real estate wholesaling operated in a gray area in Iowa. Somebody would find a homeowner, get them to sign a purchase agreement, and then, without ever actually buying the house, turn around and sell that contract to a different buyer for a profit. Some of that activity was arguably allowed. Some of it raised real questions about unauthorized real estate brokerage, about what the wholesaler was telling the seller, and about whether the contracts were even enforceable. Often, it was totally invisible to the seller, and in a lot of cases, the seller never knew that the person they signed up with wasn't the person who would actually end up owning their home. Iowa changed that. The new rule pulls wholesaling out of that gray area and puts it into its own regulated category. And it requires wholesalers to be upfront with you about who they are and what they're doing before you sign. The point isn't to ban wholesaling. The point is to make sure you aren't signing a contract with somebody you think is buying your house when in fact they're buying the right to sell your contract to somebody else. Think of it this way. If you're selling a used car, there's a difference between selling it to the person who's going to drive it and selling it to a guy who's going to flip it to somebody else by the end of the week. The transaction looks the same on the surface, but the price, the speed, and your leverage all change depending upon which one you're in. Iowa's law says you get to know which one you're in before you commit. That's the change. Now let's talk about who wholesalers actually are, because most sellers I meet don't realize the cash offer in their mailbox came from one. A wholesaler is not an end buyer. They're not the person who's going to close on your house, move in, rent it out, or hold it as an investment. A wholesaler's business model is to lock up your property under contract, then find another investor who wants to buy it at a higher price and pocket the difference. The difference is called the assignment fee. Sometimes it's a few $1,000s, sometimes it's $20,000 or $30,000. And historically, under the old rules, a seller might never see that number at all. Here's the part that surprises most sellers. If you've gotten an unsolicited postcard in the mail offering cash for your house, a handwritten looking letter saying, "I'd love to buy your property," or even a text message from a local 515 or 319 number, or a cold call asking if you'd consider selling, there's a very good chance that person is a wholesaler. Not an investor with cash in the bank, not a builder, a middleman. That doesn't mean they're doing anything wrong. Some wholesalers do run honest businesses, but it changes the math on what your house is worth to them, and it changes what questions you should be asking before you sign. So what are you now entitled to know? Under Iowa's wholesaler rule, there are a few key things a wholesaler has to disclose to you in writing. First, they have to tell you they're a wholesaler, meaning they have to be upfront that their plan is to assign your contract to another buyer, not to take title themselves. If the contract in front of you says cash buyer or uses the name of an LLC you've never heard of, but nowhere does it tell you the buyer's actual plan is to flip the contract, that's definitely a red flag. Second, they have to disclose that they don't intend to be the end owner of the property. This one matters because it directly affects your risk. If the wholesaler can't find somebody to assign the contract to, the deal can fall apart, and you've now lost weeks of market time for a buyer who was never really buying. Third, they have to disclose the assignment fee, or the markup, what they're making in the middle. You get to see that number. In the old days, that was a black box. Now it isn't. If you're looking at a cash offer on your house right now, and none of those three things appear anywhere in the paperwork, that is your signal to stop and get a second set of eyes on it. A missing disclosure doesn't just mean the deal is probably bad for you. Depending upon the circumstances, it can also affect whether the contract is enforceable against you at all, which is a very different legal position to be in than you probably realize. Let me zoom in on one specific thing to look for in the contract itself. It's a phrase that reads something like buyer and or assigns, or buyer, his heirs, successors, and assigns. It'll be right next to the buyer's name on the first page of the purchase agreement. That phrase by itself isn't the problem. Many standard real estate contracts have some version of it, but in the context of a cash offer from somebody you've never met, it is a very strong signal that the person you're signing with doesn't plan to be the one who closes. They're reserving the right to swap themselves out for somebody else at the last minute. Here's what that means for you as the seller. If you're 15 days from closing and the wholesaler hasn't found an end buyer, you can end up in a situation where the closing date moves, or the deal falls apart, or a new buyer shows up at the table who wants to renegotiate the price. None of that is necessarily fraud, but all of it is avoidable if you knew what you were signing in the first place. So look for that and or assigns language. If it's there, you are almost certainly dealing with a wholesaler, whether the word wholesaler appears anywhere in the paperwork or not. Quick pause right here. If you're watching this and you already have a cash offer on your kitchen counter, the contract is sitting there, maybe there's a deadline to sign, this is the moment to stop guessing. The link in the description books a short call with my office. If we're a fit, you'll sign an engagement letter and hire us, and then we go fast. For most people, that review ends up costing less than 1% of the sale price. Our guided package gets you purchase agreement reviewed within 1 business day of hiring us. Our assured package can turn it around the same day. Links in the description. Now let's keep going. So what's the right move in the first 48 hours after an unsolicited cash offer shows up? Here's a simple checklist. Step 1, don't sign the same day. I know, that's hard. A lot of these offers come with urgency built in. This price is only good through Friday. We have another seller waiting. That pressure is part of the pitch. A legitimate buyer will still be there in 48 hours. If they aren't, they were never the right buyer for you. Step 2, read the contract slowly with a pen in your hand. Flag the name of the buyer. Look for the and or assigns language. See if the 3 disclosures I just walked through are anywhere in the document. Step 3, compare the offer to what your house would actually bring on the open market, not Zillow. A real comparison, either from a realtor you trust or a local appraiser. A lot of wholesalers offer well below market value, often somewhere in the 60 to 75 cents on the dollar range, sometimes less. There are situations where that math still works for a seller, maybe an inherited house, a property that needs major repairs, a timeline problem. But you should be going into that decision with your eyes open. Step 4, get a second set of eyes on the paperwork before the deadline. Now, are you legally required to hire an attorney to review every cash offer? No, the state doesn't force you to. But here's the reality. The contracts that turn into horror stories almost always have the same pattern. Nobody reviewed them before they were signed, and the seller didn't know what to look for. So instead of asking, do I have to hire an attorney? A better question is this one of those situations where I'd be taking unnecessary risk if I don't? Here are the 3 situations where I'd tell a seller it's worth hiring somebody. 1, the offer feels rushed. The buyer is pressuring you to sign before the weekend. 2, the paperwork is confusing. The buyer's name is an LLC you can't find online, or the contract language doesn't match what you've seen in other real estate deals. 3, the offer is significantly below what you think your house is worth, and you want to understand what you're giving up. At my firm, we work with sellers in 3 different ways. A focused review, where we go through the paperwork and tell you what we see. Our guided package, where we stay with you all the way through closing. And our assured package, where we're on every wire and every signature from the offer through funding. The right fit depends upon how complicated the deal is and how much peace of mind you want. All 3 start with a short call. Here's the short version of everything we just covered. Iowa now requires wholesalers to tell you who they are before you sign. Look for the and/or assigns language and look for the 3 disclosures: wholesaler status, intent not to take title, and the assignment fee. And give yourself 48 hours before you commit to anything. If this was helpful and you want the next level of protection, there's a free PDF linked in the description called 10 Things Every Iowa Seller Should Check Before Accepting a Cash Offer. It's a simple, pre-signing checklist that walks you through the big items sellers miss. Comparing the offer to true market value, what's actually being sold, earnest money red flags, inspection and due diligence windows, and/or assigns language, proof of funds, title issues, possession terms, your net proceeds, and why it's smart to have an Iowa real estate attorney review the offer before you sign. It pairs well with what we just covered. If you've got an offer in front of you and you want a real person on it, that same link includes a way to book a short call with our office. Subscribe if you want more short videos like this one on Iowa real estate. And as always, this is paid attorney advertising. Everything I covered today is general information, not legal advice for your specific transaction. If you've got a real deal in front of you, get it reviewed.